Good morning and welcome to today's episode of Goff Square Live. I'm Sabrina Goodchild and today we're going to dive a little deeper into the Digital Markets, Competition and Consumer Act 2024, more pithily known as the DMCC. On the last episode of Goff Square Live, David Travers KC gave us a whistle-stop tour through the 340 sections and multiple schedules of the Act, with a focus on the overall structure and key changes expected when the Act comes fully into force, which is now expected to be early next year. But don't hold me to that, I don't have a direct line to the Department of Business and Trade. Do give David's episode a watch on YouTube channel if you've missed it. This episode, however, is looking at the few chapters of the Act that deal with enforcement of consumer protection legislation. Many of the provisions that we will go through will sound very familiar to those who have enforced CPUT or the Enterprise Act before. So I'm going to focus on the new CMA direct enforcement regime, but will highlight key changes to the old regime. With that in mind, I'm going to look this morning at, firstly, the court-based civil enforcement regime, second, the court-based criminal enforcement regime, and then finally the CMA's direct enforcement regime. So, starting with the civil enforcement regime, which is found mainly in Chapter 3 of Part 3 of the Act. You'd be forgiven for thinking that this regime, which is available to the CMA, trading standards authorities, and sectoral regulators such as the FCA, Ofcom, the CAA, etc., is just a lift and shift of Part 8 of the Enterprise Act. But what is intended is a simplification and enhancement of the Part 8 regime. You've still got provision for enforcement orders, interim enforcement orders, online interface orders, interim online interface orders, and enhanced consumer measures. But what are the enhancements to Part 8? Well, the key enhancement is the ability to impose financial penalties. Under the Enterprise Act regime, financial orders can only be imposed where there is a proved loss. Under the new regime, no such loss will need to be proved before a financial order can be made. In effect, the regime sharpens the stick of an enforcement order. So as part of the enforcement order package, the court can impose a requirement to pay a monetary penalty of up to £300,000 or, if higher, 10% of global turnover. And if a trader has provided an undertaking and subsequently breached it, an enforcer can apply to the court in respect of that failure. On such an application, the court may impose a financial penalty for non-compliance of up to £150,000 or, if higher, 5% of the total value of the turnover, plus daily penalties. Now, in order to make such an award, in circumstances where there's been a breach of an undertaking, the court must be satisfied that the trader's failure is without reasonable excuse. So not only is the stick of an enforcement order sharpened, but the benefits of accepting undertakings is significantly increased, as breaches can be enforced through the courts without having to seek an enforcement order first. Separate to the enforcement order regime, there are now new penalties for failing to comply with an information notice without reasonable excuse of up to £30,000 or 1% of turnover, plus daily penalties. The headline: yes, it's a lift and shift, but the civil enforcement regime now has more bite. The effect? Well, we might start to see more use of a historically underused civil enforcement regime by enforcers as a real alternative to prosecution. And while I've been plugging previous Goff Square Live episodes, do catch up with a recent episode that Cameron Crowe and I did on enforcement orders, where we look at the key pitfalls in the regime and how to avoid them. Most of that commentary will be equally applicable to the new regime. The next headline regime is the criminal enforcement regime, which many of you will start to use, given its application to the CMA and trading standards authorities when it comes into force. This regime is found in Chapter 1 of Part 4 and replaces, with very minor amendments, CPUT, which, as before, is enforceable through criminal prosecution. So these are your misleading actions, misleading omissions, and my personal favourite, contrary to professional diligence prosecutions. I won't say anything else on this for now, as the CMA are expected to consult later in the year on separate substantive guidance on this part, so we await with anticipation to see what is said there. So without further ado then, I'm going to move on to the meat of the talk, the CMA direct enforcement regime. Now this regime, for the first time, allows the CMA to investigate, determine, and take enforcement action to address breaches of certain consumer protection laws, breaches of undertakings given to the CMA, breach of CMA directions, providing false or misleading information to the CMA, and non-compliance with information notices, all without recourse to a court. Whereas, of course, historically, only a court can determine such breaches and take action to stop or rectify them. Now, the reason I'm talking about this now is the CMA's open consultation on its draft guidance, which runs to a hefty 129 pages, and also its rules, which closes on the 11th of September, so in a few days' time. The DMCC gives little away about how the CMA's new powers will be exercised, so the drafts provide a useful insight into the CMA's thinking. And whilst, of course, the CMA will take into account the consultation responses, the reality is that the final guidance is unlikely to change substantially from the draft guidance. And when we have the final guidance, it's also likely to be useful to other enforcers, for example, when considering what a reasonable excuse is when trading standards authorities are considering bringing proceedings for breach of an undertaking. The courts may also give consideration to it when determining what financial penalties they impose under the court-based enforcement regime we've already discussed. So what insight can we get from the CMA's draft documents? Well, in my opinion, it's twofold. First, we get insight into the CMA's process for how it will conduct direct enforcement investigations. And then second, we get an insight into the penalties process. I'm going to take each in turn, but before we do, let's look briefly in a little more detail about what these powers, in fact, are. So what are these powers? Well, there are 6 key powers, which are summarised at a very high level on the slide that you should be able to see. These are split into substantive penalties and administrative penalties. Starting with the substantive penalties, first, under Section 182, a final infringement notice may be imposed, which provides for directions, including enhanced consumer measures, basically requiring a trader to take certain steps or stop taking certain steps, and also may impose a monetary penalty of up to £300,000 or 10% of total turnover if higher. Second, the CMA may issue under Section 184 an online interface notice, directing an infringer or third party to modify or remove infringing online content. And then third, the CMA may accept an undertaking pursuant to Section 185. The guidance provides some indicators as to when an undertaking will be an acceptable resolution. The CMA say they are more likely to accept an undertaking where it will adequately address the CMA's concerns and where it can be implemented effectively within a short period of time. They are unlikely to accept an undertaking where it doesn't satisfactorily address their concerns, where there's been a previous failure to comply with an undertaking, or where compliance is difficult to monitor or where it would undermine deterrence. And those are features that other enforcers may want to take into account in due course when considering accepting undertakings. Now, I said there were substantive and also administrative penalties. So we've been through the substantive penalties, but there are also 3 key administrative penalties. The first is where there's been a failure to comply with an undertaking that was previously given. A final breach of undertaking's enforcement notice under Section 189 may be imposed. And this may impose directions, so again, telling a trader what they can and can't do, and also a monetary penalty where the breach is without reasonable excuse. And the monetary penalties are a little bit less. They're £150,000 or up to, or 5% of turnover plus daily penalties. As a brief interlude, the CMA had provided draft guidance on what constitutes a reasonable excuse. So examples of reasonable excuse include a significant and demonstrable IT failure, which could not reasonably have been foreseen or avoided, and which prevented the meeting of a deadline for making required changes, the death or incapacity of a key official for a small business or sole trader, or a staff error where the mistake was brought to the attention of the CMA before the CMA relied upon it. So quite a specific list with restricted application. Examples of what is unlikely to constitute a reasonable excuse include failure to make reasonable efforts to meet a deadline, failure to obtain senior approval in time, and the absence of officials or advisors due to annual leave or any other planned reason. So back to the administrative penalties. The next one is a final breach of a directions enforcement notice under Section 192, imposed where there have been breaches of enforcement directions previously provided. This can amend the directions previously made and impose, again, a monetary penalty of up to £150,000 or 5% of total turnover plus daily penalties again, where the breach is without reasonable excuse. And finally, we have the provision of materially false or misleading information without reasonable excuse under Section 198, which allows for the smallest penalties of up to £30,000 or 1% of turnover. So the obvious difference between substantive and administrative penalties is this additional requirement of without reasonable excuse for the administrative penalties. So what can we take from the guidance about the CMA's process of investigating? Well, they've outlined a 4-stage process, which is summarised by their diagram in the guidance, which should hopefully appear on your screens now. So the steps are pre-launch, investigation, final decision, and post-decision. Case opening falls within the investigation stage and applies where the CMA has reasonable grounds to suspect that a person has engaged, is engaging, or is likely to engage in a commercial practice that constitutes an infringement of Schedule 16, or a person is an accessory to the practice. Schedule 16 contains the sort of legislation you'd expect, so significant proportions of the Consumer Rights Act, parts of the DMCC relating to unfair commercial practices, subscription contracts and consumer savings schemes, KIC Act, the CCA, parts of the Sale of Goods Act 1979, provisions relating to comparative advertising under the Business Protection from Misleading Marketing regs, etc. So once the case has been opened, we then move into the investigation stage, where the CMA will use their compulsory or may use their compulsory powers to seek information and may have discussions about the possibility of undertakings, as we've discussed, and settlement, and apply potentially for an interim enforcement order from the court whilst investigations continue. Now, useful guidance is provided on settlement in the draft guidance. In effect, a party can admit to infringing consumer law, agree to accept a final infringement notice and not to appeal it for a reduction in the financial penalty. So, as may be expected, settlement is at the CMA's discretion, but they say they are more likely to consider it where procedural efficiencies and resource savings can be achieved. The discount to the financial penalty, like in the criminal courts, very much depends on the time that resolution is reached. So the maximum discount is available prior to the issuance of a provisional infringement notice, which we'll come to in a moment, and is up to 40%. But the maximum then reduces post the provisional infringement notice, the PIN, to 25%. In effect, the CMA are encouraging early and swift resolution. The next step within the investigation is a provisional infringement notice, as we've just mentioned. It's issued effectively where the CMA think there is a breach. That allows then the opportunity of the parties to inspect the CMA's file, time to respond in writing, which will generally be between 20 to 30 days from the PIN, and the CMA will then generally offer an oral hearing. The CMA intend for this hearing to be chaired by a member of staff who has not been involved as a decision maker or in the day-to-day running of the investigation. They will require an agenda to be agreed in advance and for matters not already raised in writing to be flagged well in advance. The next stage is the final decision, where a final infringement notice, a FIN, may be issued. This is where the directions, enhanced consumer measures and monetary penalties we've already discussed come into play. Notably, monetary penalties can only be imposed in respect of practices that have been engaged in by the trader. So it's not sufficient if they were only likely to engage but haven't yet. Traders can then also expect a press announcement and for the decision to be published. Finally, we move to post-decision. So parties may appeal to the High Court on the grounds that the decision was based on an error of fact, the decision was wrong in law, the amount of the penalty or nature of the direction is unreasonable, or that the decision was unreasonable or wrong for any other reason. The majority of appeals must be brought within 60 days of the notice, but some administrative penalties must be appealed within 28 days. Importantly, any monetary penalties do not need to be paid until after an appeal is determined, but any non-monetary requirements must be complied with. There's also the option to apply for time to pay any monetary penalties, which of course we know may be quite significant, but any failure to pay will result in a civil debt with the usual routes of enforcement open. Administrative breaches have a very similar procedure, but it's slightly modified, so do have a look at the guidance for further detail. The second headline of the guidance that I mentioned at the start is how penalties are calculated. So this part will likely be of most interest to businesses who are facing CMA enforcement action, and also, as I've already mentioned, it may be informative to the courts when considering what penalties they apply under the court-based enforcement regime. So the CMA have set their own objectives when considering monetary penalties, as first, deterring infringements and incentivising compliance with consumer law and remedies; second, to reflect the seriousness of the infringement and breaches; and then finally, to encourage the parties to fully cooperate with the CMA investigations so that they are able to take timely decisions based on accurate and complete information. Now, I've mentioned worldwide turnover numerous times, and we know that the penalty for substantive breaches is up to 10% of worldwide turnover. Unsurprisingly, given the CMA's focus is on the UK market, they've stated that their intention in the guidance is to use 30% of UK turnover, so not worldwide, as the starting point, using the last full year's figures preceding the date on which the infringement ended. This will then be checked against the worldwide turnover to ensure the cap is not exceeded. The CMA have stated that for the substantive penalties, they intend to apply a 5-step approach to determine the appropriate penalty. Those who appear before the criminal courts may think that some of these steps sound very familiar to the sentencing guidelines that are now increasingly common for regulatory offences. So step 1 is calculate the starting point having regard to the seriousness of the infringement and the relevant turnover. So this is determined in the usual way by reference to harm or risk of harm and a party's culpability. You can hopefully see on your screen the 4 different categories of harm, with category 1 being the highest and category 4 being the lowest. We then have a list of escalating factors which may justify moving, at this stage, infringements into a higher category. So these include particular impact on vulnerable consumers, infringements which predominantly involve products of an essential nature, and infringements which have caused an individual consumer to suffer large economic or non-economic losses. Then there is a similar table for culpability, with high, medium and low, which you should hopefully also see on your screen. Examples of high culpability include business operations which regularly involve the infringing practice, a party operating a deliberate strategy to carry out practices that amount to an infringement, or businesses that have previously received advice. Then your culpability and harm categories allow you to identify a starting point code from high A to low D, which can then in effect be plugged into the third table which I'm showing you today, which gives the monetary and percentage of UK turnover starting points, and you should hopefully be able to see this on your screens now. We then move on to the second step, which is an adjustment to these starting points for deterrence and to take into account a party's size. This is where worldwide turnover comes in, and potentially looking at 3-year turnover averages if 1 year is insufficient. Step 3 is an adjustment for mitigating and aggravating features, which include full redress having been paid prior to the PIN, cooperation with the CMA, previous breaches or attempts to conceal breaches from the CMA. Step 4 is an adjustment to ensure the penalty is proportionate and the 10% cap is not exceeded. And then step 5 is the settlement discount, which we've already discussed. So that's the process for substantive penalties. The administrative penalties follow steps 1 to 4, but with slightly different tables and slightly different escalating factors. It's hoped that these detailed guides, once finalised, will bring a degree of predictability and consistency to a process that is not heavily prescribed by the DMCC, and affords the CMA a significant degree of discretion outside of the usual court process. Any changes to the final guidance, along with how proactive the CMA will be with their new powers, remains to be seen. That's everything for today. I hope it's been helpful, and if there are any questions, do get in touch. The next GovSquare Live will be on the 1st of October on product recalls. Thank you and good morning.